You're telling the truth, man. Give me a break. You also went after him. Right. You tell the truth. Twice I held you back. All right. Hey, do you understand? I'm going to call this.
Unless you throw some of these people out for like paying.
You be on a board?
What?
You run on a board?
Jerry Merrill in the back. That's one way to get rid of him. I want him out of here. He's a rabble rouser. Take him out.
I'm cool. I'm cooling right here.
Ladies and gentlemen, I apologize for the interruption. I'll try and pick up where I left off. If I could have your attention.
I didn't assault anybody. You know, I didn't do anything.
Let it alone. Let it alone.
I didn't say a word. I'm not saying a word.
You know what? Sir, Howard, let it alone.
All right.
Let it alone.
I need help.
Edwin. All right, I'll continue.
Yes. Okay.
The provisions of Florida statute and the rules, as I was saying, allow for the restrictions that these particular rules have identified. In fact, they were prepared by prior council back in 1995, and they were in place for a while, but at some point they were not followed. The readoption by the board would be within their authority under current Florida law.
Okay, now we'll go back to the first issue, which was the board's authority to remove a board member. And I'll take questions from the board. Any questions from the board? Okay, from the unit owners, if you have questions on this, right. Come on up, Bill.
Why? Why? Do you have a question? My question is why?
We're not,
The question should be addressed as to the legal authority, not the actual fact. That will be later in the meeting.
It's the actual fact that I withdraw.
okay, okay. Anyone else want to say anything on this issue? Yes, go ahead.
Do you have proof of the actual thing that the person did that you wanted to throw him off?
We're not discussing that. We're discussing the board's right to do it.
Well, the board doesn't have the right unless it has proof.
The provision of the statute indicates that the removal can be with or without cause. It does not require there be a cause, a specific reason that the board votes to do it. It just gives the board the power to take that action.
Are they asking questions now?
Yeah.
It's subjective, but the board has the right.
They will, I was
to
asking
throw
how come
somebody
I
off
was removed.
without-
Only the individuals that have been appointed by the board itself. Not every board member is subject to this. So apparently there's only one current member of the board who is appointed.
The right.
Well, it isn't exactly the same as running the country. It's a corporate function, which works under different
So if
rules.
you don't like somebody, you just throw them off. No.
That is an option that the law allows. If people can't work together, the board can certainly make the decision to make a change under those circumstances. The goal of the board is to work together for the betterment of the entire condominium and not to be infighting, as has been the history, if that's possible.
Okay, Jerry, go ahead.
You have earlier given the opinion.
Ladies and gentlemen, I can't hear, so if you mind.
You have earlier given the opinion that the board had a right to remove a sitting board member. Now you're giving the opinion that the board has the right to remove an appointed board member. And there happens to be 3, not 1 appointed board member on the board currently. There's 3 board members. To me, that appears to mean that the majority of the board can control whoever is on the board. And it so happens that's never been done. I mean, there has been situations in the past where your present majority has been in the minority. And the majority in those days never would even think of removing them, even though they would like to. You are telling us in both instances a duly elected board member can be removed. And well, you said you did in the case of Mr. Pickus. In this case of Mr. Pickus, you said he could be removed. That's what we were told.
That's a different situation.
Well, that's a
not
sitting
what we're
board.
talking about tonight.
That's a sitting duly elected board member, and he was removed. He was removed. Now you're taking a case of an appointed board member, and he's being removed. That means the majority board has the ability to rework the board to their favor.
Right.
And to me,
Do you
that
want to hear
makes
my
no
answer?
legal sense. Yeah, I would. I have to give you the question.
Thank you. The reason that this may not have ever been done before is because the statute was adopted effective July 1, 2009. It was never available before. So
Repeat that statute, would you please? Because that was just something you said early on. What is the new statute that's allowing that?
Section number 617.0808 of Florida statutes, as it applies to all not-for-profit corporations within the state of Florida, of which International Village is one. There is no current exception in the law for community associations falling under this particular provision, and it does allow for the board to remove an individual board member that had been appointed by the board itself. For so long as the statute remains in place, the board has the legal authority to take that action. I'm not giving any opinion as to whether they should or shouldn't, because that's for them to decide, not for me. My function here is to simply report what their legal entitlement is. Now, with Mr. Pickus in the past, the opinion was that there had been a missing of the number of meetings that the bylaws provide for, and that the procedures that were followed were not in accordance with what the statute provided. It was not an agenda item to reappoint or excuse the absences. It was not added by a majority plus 1 of the board as required under Florida statute, and it was not ratified at the immediately following meeting, which is also required under Florida statutes. Without meeting the statutory requirements, there was no elimination of the original failure under the documents, which meant upon that point in December of 2008, he remained off the board the entire time. So the board did not remove him. It was a function of your documents.
But you say that's only by recall a board member can be removed. And here you're contradicting yourself.
Your documents provide for upon
You just
missing a
contradicted.
certain number of meetings, it's a deemed resignation,
No,
not a
well,
recall. It's not a
That
removal.
was your opinion, but not Katzman's. Katzman had a contrary opinion.
Well, Katzman isn't here at the moment, I am.
Did you read his opinion?
I did.
Did you disagree with it?
I did.
Okay, we'll let him know.
Please do.
But you just contradicted yourself. You said
No,
it's
I
sitting.
didn't.
Yes, you did, sir. Sorry.
You're hearing what you want to
I
hear.
heard what you said. You said only a recall can only take an elected board member off, and you just
No, I
contradicted
said
yourself. That's what
the
you
removal
said.
of a board member is accomplished by recall. However,
Only
your
by-
documents provide for a deemed resignation, which is not a removal.
No, sir.
Deemed
It's a
resignation.
legal distinction.
That explains it.
Twisted tongue. Sorry.
even if there are extenuating circumstances which prevent a board member from being present.
Well,
Such as,
again, that's not the issue for tonight, but
well, that's
No,
the
that's not-
issue with Mr. Pincus.
No, no, we're not talking about Mr. Pickens.
Mr. Pickens could certainly have been reappointed to the board by the board, but the problem was the procedures followed at the time were not legally correct, which resulted in not happening.
Any other
Because
questions
because
on
of
this?
Katzman's advice that the meeting was moot, we never redid it.
Correct.
Yeah,
Let's
right,
move on to the
exactly.
next one.
It
That
was
was
because
over.
of Katzman's direction that the meeting was never redone.
That was offered prior to the owners.
But I was outside,
No, you
It's
weren't.
Katzman's responsibility.
I was not sitting there, I was out with the
Yeah,
patient.
sure, you can ask any question.
Can I have a microphone for you?
That one's not working. All right, has it been?
I don't need a mic, I don't need a mic.
Hey, yeah.
Obviously, my first question to Robert is, how much is the board of directors and the unit owners paying you for your time tonight?
That's not relevant.
It is very relevant.
The only thing that's relevant.
Wait a minute, can I interrupt?
The only.
Now you're interrupting me.
If you have a question about this issue that's on the table, which is the board's authority to remove a board member with or without cause, whom the board previously appointed or elected to fill a vacancy, that is the only thing that's germane. It's got nothing to do with anything else
But if
in
he
the
asks
law.
a question, he's got to answer it. He's asking,
What is he afraid? All right, I'll ask him another question. You have, on the topic, right on the topic, you have given us what I call legal mumbo jumbo. Now, Dove hired a lawyer to represent him so he can interpret and defend the position. You used Scott and you forced us to have him leave. My question is, what are you afraid of, since an attorney would be talking to an attorney? I have no idea. You're quoting all kinds of things. How could we possibly know the answer when we had an attorney here which we paid to answer?
Not address the authority.
I'll answer it.
That's good.
That doesn't address it? What does?
The question was, what am I afraid of to allow the attorney to stay and address the issue? I'm not afraid of anything. The board does not want that to go on tonight. They only want unit owners present, and I follow the instructions of the board. I am perfectly comfortable in the position that I've provided to the association, and I have no problem taking that to the courts if necessary.
United States of America.
Any other board member want to speak? Okay?
That's up to the chair.
I would like to.
Give it to, you want to say something?
You need a mic?
Yeah. That's it.
It's not working.
I don't know if there is.
This has definitely got to be a recall. It's the only way.
The amount that the attorney is getting is relevant because him being here is relevant. Therefore, how much we're having to pay, it's out of our pockets. Well, let me hold on. Let me. That is an opinion. In my opinion, it's relevant because we're.
Free, or he was charging $1,000.
That's exactly
That's
It's our
we're
money.
talking about the law.
Yeah, it's our money.
It's our
It's the
money.
law. He is an attorney. Therefore, what we're paying him, how that's not relevant, is beyond me. So we're paying him. I think it should be transparent how much we're paying him, being that you are not paying out of your pocket. It's out of all of our pockets. Therefore, we should be privy to that information, and you should justify why he's here and why he hasn't been here any other meeting. There might be a good reason, but why not you? I did not authorize him being here. I was not even informed that he was going to be here. I might have even been in favor, but I was not even informed, nor was Stuart informed, which I find a little bizarre if I'm representing the people and I wasn't even informed on the fact that I have to pay out of my own pocket him being here because I am a unit owner. So I just like everyone to know that we're paying who knows what for him being here, and I was not given that information. So,
Thank you.
so could you address that, please?
No.
I'll answer it. I'll repeat what I said before. We're here to determine if the board has this authority. We have this authority according to the attorney and according to Chapter 617-0808, and This is what we're doing. And a little bit later, the board is going to take an action here. We don't want to revisit this again. That's all. Now we're going to go, no, you spoke already, and that's it.
This is like a dictatorship.
I'm not recognized.
We understand.
Okay.
why you're not recognized.
Okay. The next issue that the unit owners, Marcy, do you want to leave?
No, I do not want to leave.
Marcy, if you don't want to leave,
You
don't
cannot-
shout out.
Excuse me, you cannot control things, Stuart, Scott, you've been doing that for years. You used Stuart to get where you wanted, and now you're just doing this.
This is why we have to call the police.
Oh, right.
No, but this is why. Your contribution and everyone else.
You know what, you forgot what you.
The next issue we're going to talk about,
Yeah, Scott used to do it all the time.
the next issue, Mark, let's go on with the meeting. The association's right to implement the higher minimum income requirements on sales and lease applications that were previously approved by an amendment, membership amendment change. Is there any question about this issue that anyone has about the board raising the minimum requirements from $25,000 to a higher amount?
No.
Go ahead.
He said something, the lawyer said something about, where was the board when those minimums were raised? That he said it was a year past. A year has gone by, so now you can't do it
February
anymore, you gotta have
25th.
another meeting. Where
No.
was the board functioning at this time?
I don't get your question.
The amendment was adopted in early 2008.
February
But
25th.
the board was advised at the time that because of the lack of ability to identify, thinking that the statute that I discussed earlier was applicable, they identify which units voted for and which it should apply to, that it was not something that the board should put in place. This board is taking the perspective that that was incorrect and that it is enforceable. Now, it will be republished as I described earlier, since it wasn't enforced since adopted, and it will be applied in the future, not in the past.
Oh.
Yes, sir.
Yeah, it was filed, I was the author of that amendment.
It's recorded.
Yeah, it was recorded on
public
February
record.
25th, 2008. So the people prior to the passage, the filing of that amendment would not apply to them?
It doesn't apply to anything existing since it has not been enforced since it was recorded. So it in essence, it's
So it
gone
would go
beyond the
forward
1 year.
from the time you
On a going
reinstate it?
forward basis, it would be
When you reinstate it, it'll go forward from there.
correct.
Any other questions on raising the minimum, giving the board the opportunity for a minimum income requirements on sales and lease applications? Nothing, okay.
What about the
Okay.
board?
How much will it be? You say 25,000 is not enough. Now,
It's
how
in the
much will it
document.
be?
The amendment went up to 45,000. I believe, is that right? Can someone confirm that?
34
I can
efficiency
confirm
in the
it.
studio, 35 for a one-bedroom, 44 a two-bedroom, and 45 for three and four.
45, up to 45,000.
Depending on the unit.
Okay. Okay, anyone else here?
Is there a
No, you had your
grandfather
chance.
clause?
Who else?
Are we grandfathered
You want
in?
to talk? Anyone want to talk?
It applies going forward. Grandfather. You won't let me ask a second question?
If we follow Samuel's doctrine and we raise the minimum, what you're going to do is you're going to force people who are out of work, who are earning less money, not to come in. Right now, we have, am I right, Michael, when I say 90 or over 100 units?
135 list pendencies and over 100
From
low foreclosures.
90 days past due and above, how many?
120.
We got 120. That means there's 120 units we're collecting Zippo. If we raise the requirements by wages, we're gonna take that 135 and it's gonna zoom up. And where are we gonna pay? By the way, folks, They could
They don't
deny
live
it,
here already, they're for new people moving in.
okay?
New people moving in, and there's other places for them to live if they can't have the requirements here. It's not the only place that somebody needs to rent.
That's why we have a difference of opinion. All I'm stating is my opinion.
Well, I'd like to say something. You're not asking questions. Grandfather?
The question is, why do we want to raise the minimum and stop people that have the ability to pay from entering the village and filling empty units instead of leaving them empty where we're gaining no revenue?
I have a question.
I want to respond to that. That is not the issue here. That issue that's just been addressed by Mr. Wolf will be addressed at a board meeting when the board exercises this right to discuss that and make a decision. So this decision to raise it or not to raise it has not been done yet. Nobody said we're going to raise it. All we said here tonight is that we have the right to raise it. So you can't mix apples and oranges. That's why we're not doing this tonight. We're just getting the right to do it. Anyone else here? B, Adele?
Very briefly and very.
I can't hear you, hon.
I just want to say that if somebody comes in here with a family and they earn $25,000 a year, they're not going to be able to pay anything. So you're going to have the same thing.
They don't pay the maintenance.
Raise our standard.
You come to the meeting, Bell. That's what is going to be disputed at the next board meeting, which we plan to be in about 10 to 14 days. This issue will come to the table, come to that meeting, voice your opinion, and then the board will have talked to each other. We've analyzed it. We'll talk to the people on the sales and lease committee, and then we'll come up with a valued decision at that time, but not tonight. This was only our right to do it. Okay, any more? That's it? Okay, we go on to the next item. We have the right, association's right to implement the higher minimum income requirements. Item number 3 is also a very important one that we are not going to pass judgment on. The board is going to, we're talking tonight about the board's rights. This next one, the association, according to the attorney, cannot restrict the unlimited ownership of apartments by any party, nor adhere to the 25% cap. That was his definitive and substantive opinion. Now, anyone want to talk on the right of the board to have unlimited, or any questions on unlimited rights of unit owners to purchase apartments?
I thought that was.
I would like to, this is an issue that I brought briefly, Mr.
Speak up.
Francis, can you grab a mic?
Microphone.
Bring it to her.
Stay put.
Excuse the dramatic glasses, I had some surgery and I have a black eye. You said that the regulation had not been enforced, so therefore it was null and void. The requirement that an owner not own more than 4 units. That is not true. Within the past year, within the past 5 or 6 months, action was initiated by the law firm of Katzman and Core against unit owners who own more than 4